Part heard appeal in the matter of Unitel S.A. and Unitel International Holdings B.V. and Isabel dos Santos.
Good morning.
Thank you very much for your very helpful notes or submissions, written submissions and authorities from the Commonwealth,
Yes.
which we've read and we'll obviously take into account. But it seems to us, unless you particularly want to spend the time you've got dealing with those, we'd rather get on with dealing with the rest of the appeal. And so far as possible, we'd like to think the parties could finish, if not by lunch, by sometime soon thereafter.
Yes, but thank you, my lord, my lady.
Because we dealt with you dealt with the law, as it were, on
Yes.
what's the right test.
Yes.
And you and I got the application of that to the facts to deal with, and then there's the costs of the.
Correct. Yes, my lord. The other bit of housekeeping was we were asked to supply a copy of Madoff and Raven.
Yes.
And I hope you've received that.
Yeah.
Yes. Okay. So yes, exactly. So I was just about to, well, I had addressed your lordships, your ladyship on the law. I was going to turn to, or in fact, I just started dealing with the question whether there was a good arguable case here, because I had taken the court to a number of authorities which showed that the Court of Appeal should be reluctant to second-guess the decision of a commercial court judge. And so now I'm going to turn to the question, leaving that to one side, of whether we satisfy the test here. And before doing so, I want to make two starting observations before getting into the Angolan law. Firstly, if we are right on the legal test for a good arguable case, we submit it's impossible to see how the appellants can persuade the court that we do not satisfy that test. If a question is one of foreign law and the party has put forward an expert report from an apparently qualified expert with apparently well-reasoned analysis, which we say we certainly have, then that party clearly satisfies the threshold of something that is more than barely capable of serious argument. If the court is there not required to go on to assess whether that one party has the better of the argument than the other.
Well, it wouldn't be possible to do that without having had oral evidence and cross-examination.
Exactly.
It's
But
plainly not appropriate in these circumstances.
yes, my lord. And we would say that it doesn't mean that a party in our position has a free pass on obtaining a freezing injunction, because we still have to satisfy the court that there's a risk of dissipation and generally that it's just convenient to do so. But what it does mean, we say, is that a defendant in this sort of case is not going to be able to resist a freezing injunction on merits grounds. Our second starting observation is that Mr. Olive Cooper, who made the submissions on this point, placed a great deal of emphasis in his submissions on how our expert, Professor Vicente, was not independent and couldn't be relied on for various reasons. In particular, it was suggested on a number of occasions that he had deliberately changed his evidence to assist Unitel's case. I think your lordships, your ladyship have been provided with a copy of the transcript. But just to give two references, page 48 of the transcript, letter G, Mr. Olive Cooper says, "I'm afraid what happened in response to something was that Professor Vicente changed his evidence." And then at page 52, line B, he said he took the court to Professor Vicente's first report, and then to Professor Ribeiro's, and then he said Unitel then realised that if that is the test, it's absolutely cooked, and so Professor Vicente is obliged to change his evidence.
Yeah.
So that, obviously we take issue with that, which is the most serious allegation one can really make against a independent expert. But the problem for the appellant in adopting that approach is that is fine as an argument after trial, but can't seriously be adjudicated upon at an interlocutory stage without cross-examination of the expert. A fortiori, where this is being done in the appeal court, And really, the approach that a party in the appellant's shoes needs to take on this sort of application, if they have any chance of succeeding, is to say to the court, well, let us assume, for the purpose of this application, that Professor Vicente's evidence is correct, and let us assume that he is a credible expert. Nevertheless, we, the appellant, argue that they do not have a good arguable case for various reasons. But they did not do that. Instead, they have mounted a full throttle assault on Professor Vicente's character, expertise, and the correctness of his conclusions. And respectfully, we say that the court cannot possibly form a safe view on that, and certainly not without cross-examination. So quite a lot of the submissions made by the appellant were aimed at the wrong target, we would say. With those two preliminary points out of the way, can I then address the court on Angolan law? Just to be clear, as your lordships, your ladyship are all well aware, I think, is that it's not said that we don't have a good arguable case generally on the merits. In other words, Mr. Santos does not challenge our case that we have a good arguable case, she acted in breach of her duties, and so on. The only issue that is taken is one of a technical issue of Angolan law, which arises under Article 81 of the Angolan law on commercial companies. Your lordships and your ladyship will be familiar with that provision. It's in the supplemental bundle behind tab 10. Page 107, this is part of Professor Vicente's report, but it's convenient just to look there. So it's tab 10, and it's page 107.
Yeah.
And his translation is at paragraph 7,
Yeah.
which is common ground as being accurate.
Well, the judge sets it out.
Yes, that's right. And so the question, obviously, as the court will remember, is the question: what step is required to file an indemnity action within 6 months of the date of approval? Okay, before we look at Professor Vicente's analysis, can I just invite the court to look at his CV, which starts at page 90 of this bundle behind tab 8. And in section B, there is his curriculum vitae, where it will be seen he is a professor of law in University of Lisbon and has a lot of visiting professorships, memberships of various organisations, and involvement in a large number of books, and so on. And then section C specifically focuses on his Angolan legal experience, where the court will see that he has considerable teaching experience in the Angolan context, and experienced as an arbitrator and legal expert in Angola. That, I should say, is to be contrasted with my learned friend's expert, Professor Ribeiro, who it's common ground, or it's not disputed, that she has no Angolan expertise. She has expertise as a Portuguese legal expert, but none at all in Angola. The point being made by my learned friend is, well, the law is the same. But in my submission, it's obviously preferable if someone has actual experience of Angola, even if Angola does pay attention to Portuguese law. But having looked at his CV, which in my submission satisfies the test of being showing a reasonably credible expert, there we can pick up the professor's analysis on this issue, please, at page 107 of the bundle behind tab 10. And he identifies paragraph 8, the step that is required, which is filing an action, or, as he explains later, carrying out before the competent court another procedural act, whereby the company exercises its right to claim from a director. And then paragraph 16, he emphasises that one must adopt a purposive approach to consideration of the rule. At paragraph 19, he identifies the purpose here, which is 2 in number. Firstly, fulfilment of the need for security and certainty as regards subjective rights. And secondly, protection of the interests of the passive party. And then at paragraphs 23 to 25, he analyses what is meant by filing the indemnity action. And his conclusion at paragraph 25 is that for the purposes of Article 81, the filing of an application to commence proceedings would be sufficient. And then paragraph 27, he addresses the situation in front of a foreign court, where he says it's necessary to consider whether there is a different procedural act which expresses its will to recover the loss sustained by the company. And then he asks a question at paragraph 28 as to whether this is satisfied by requesting the joinder of a director, and he answers it in paragraph 29 as yes. And that is his clear evidence on the issue before the court. At paragraph 30, he goes on to say, in sum, what matters for the purposes of Article 81 is that the effect of the act performed by the claimant company is that of putting the director in the position of a respondent. And this is where, again, another problem with Mr. Olive Cooper's submissions was that in his submissions at page 51 of the transcript, letter E, he stated with confidence that to be, and I'm quoting him now, to be clear, when Professor Vicente is using the word respondent here, and he's talking about this paragraph, he does not mean respondent in the way that we would use that term. He means defendant to a claim. Well, that's Mr. Olive Cooper's interpretation, but it's not something in my submission that can be stated by him. And if one reads the wording of the expert report, that is not what the professor says. And indeed, that is supported, as I will show your lordships and your ladyship, from the third expert report of the professor that we will come to in a moment. So, and then picking up the professor's conclusions at paragraph 43 of his report, he sets out there in 8 sub-paragraphs his conclusions, which appear on any view to be prima facie a convincing analysis of Angolan law and a logical application of the analysis that he has set out in his report. And his conclusion is that the steps that were taken in this case were sufficient for the purposes of Article 80. We then have against that the report of Professor Riviero, which starts at the next tab. And if we can pick it up, please, at paragraph 9, which is on page 121. She starts by saying that Article 80 is open to interpretation and that interpretive labour can lead to different results, which in our submission is not a very promising starting point for a contention that only one particular interpretation of the rule provides a good arguable case. She then goes on at paragraph 10 to say that the principles of interpretation require consideration of a number of different factors, including grammatical, literal, logical, rational, teleological, systematic, and historical. So in other words, a complex process, it appears. The experts are in agreement, as is clear from paragraph 15 of her report, of what the essential purpose of the law is in this case, which is fulfilling the need for security and the protection of the passive party. And then we come to her conclusion at paragraph 18 and 19, where she opines that legal security and certainty can only be maintained if, in the UK courts, the act of filing the application for permission to join a party is procedurally equivalent to filing an action. And then at 19, there are two key questions, she says, that arise from that. A, whether when faced with a request from the company, the judge is obliged to authorise it. And B, once the judge has authorised it, then there's no further steps required for the action to be considered filed. But we submit that it's completely unclear from what authority or analysis she has been able to derive these two sub-questions of paragraph 19. They are not said to flow from any provisions of Angolan law or Portuguese law, or from indeed the grammatical, logical, rational, etc., or even historical analysis of the article. She has derived them, apparently plucked from the air, and they may or may not be correct, and indeed it's the opinion of Professor Vicente that they're not correct. And indeed, in coming up with this, these two sub-questions, she has ignored the fact that Article 80 uses the word file. Well, the question is, what is the meaning of filing an action? And a filing, certainly from an English law perspective, is an administrative act. It's not a judicial act. And yet that seems to run contrary to her analysis. And filing is an action that someone takes rather than a legal consequence. And so Professor Vicente reached a different conclusion on what legal certainty and security requires. But in my submission, just looking at these two reports, the court cannot possibly form a view as to which expert has the better of the argument, if that were the test, but which of these experts is correct. And indeed, then if we move on to paragraph 25 of the Professor Ribeiro's report on page 125, she summarises her views and has now added a third requirement that there are three things now that she says that the Act has to satisfy. First, that the judge is obliged to accept it. Secondly, no further act to the company is required. And thirdly, from the moment the request is made, the director obtains the status of a defendant. Now, the submissions made by Mr. Olive Cooper on this were a microcosm of the problems that they face on this appeal in my submission. Because if one goes to paragraph 54G of the transcript, he said about the Professor Ribeiro's report. He says, Professor Ribeiro has identified 3 trays that she considers a joinder application would need to have. And then he says this, even if this court said, well, actually, I'm not sure that one of those trays really is required, if you ask...
Where are you reading from? Oh, got you, yes.
Yes, 54G.
Yeah, got you.
Yeah, well, so he's suggesting, he's putting words into the, imagining the court saying, well, actually, I'm not sure one of those trays really is required. If you're all satisfied that just one of those trays is absent from a joinder application, needs to be present, this is fatal to Unitel and its claim. But, my lords, my lady, it's just not credible that your lordships and your ladyship will say to themselves, well, you know, we've read Professor Riviera's report and we think she's right on requirement A and B, but not C or something. As in, it's just not the exercise that this course is carrying out to decide whether Professor Riviera is right about 1, 2, or 3, or none of her procedural requirements. That is a misunderstanding by the appellant of the exercise before the court. But in actual fact, Professor Vicente's evidence is that she is wrong on all 3. And we see that in his report behind tab 12, at page 129. He addresses each of the 3 requirements. So at paragraph 11, he deals with the question, her first suggestion that when faced with the application, the judge must be obliged to accept it. And he points out, well, that even in Angolan law, that's not the case. And that faced with an application for a new claim, an Angolan judge could reject it altogether or invite the claimant to complete it or correct it in a certain way. So the filing of an indemnity action is in substance in Angola an application for a new claim which will proceed only if the judge accepts it, according to this analysis. And that is, we say, functionally equivalent in our jurisdiction to an application for permission to join a party to a claim. Secondly, paragraph 13 of his report, Professor Vicente addresses Professor Riviera's second criterion, and he explains why it cannot be a requirement that no further act of the company is required for there to be a claim for damages against the director, because he explains that in Angola you could have a situation that a claim for a declaration is later amended into a claim for damages. And then the third one is quite revealing, we would submit, and just spend a moment looking at that one, where he deals with the question of whether it's required that the person take the status of a defendant immediately. And he says that's not the case, because there is a procedure in Angolan law called a provoked intervention. And he explains that in paragraph 16 of his report, where he says that a provoked intervention is a procedural incident that arises alongside the main dispute. And some sort of procedure is followed. And then about 5 lines down in paragraph 16, he says, if the incident is decided favourably, the intervening party only obtains the status of a defendant in the main proceeding as of the moment when the court has allowed the intervention. And then he goes on 4 lines from the bottom of that paragraph to say that when something doesn't happen in Angolan law, he says, when an application is filed for a third party to intervene in pending proceedings, which, if applied for in respect of a company director, would be sufficient to satisfy Article 81. So this, in our submission, is a very close analogy then to applying to join a party to proceedings, because it seems like what happens is one files an application under this procedure for a third party to intervene in the proceedings, but the third party doesn't actually become a defendant until that application has been resolved one way or another and the court has allowed it. Nevertheless, it is Professor Vicente's evidence that the company director, it would be sufficient for the purpose of Article 80 from the moment the application is filed. And so that, if that evidence is correct in our submission, then that is really the closest analogy one has to the procedural situation in our case. and is confirmation, we would say, if one is looking for a functionally equivalent procedure. That applying to join a person to English proceedings is the step that is necessary. Filing the application is the step that is necessary, and it's not the actual decision of the judge to allow that application. Now, that is a statement by him of Angolan law, made by reference to some specific provisions of Angolan law. If there is an answer to that question, it must come from an expert in Angolan law. One can't just answer that submission by way of sophistry or application to logic. One needs some Angolan law to rebut that. And yet, that report was filed on the 5th of September 2023, and there has been no attempt to respond to it with a contrary report from Professor Ribeiro, either before Mr. Justice Bright or before this court. And so we say that stands as good evidence of Angolan law and uncontradicted evidence of Angolan law, and is of itself a complete answer to the claim. And what is very notable about my learned friend's skeleton in this appeal, where they are putting their best foot forward on all issues in this appeal, that is their chance to argue this case as best they can. But if one looks at their skeleton argument in the appeal, which is in the core bundle behind tab 2, where they spend a lot of time going through the law on the need accession and so on, which is all very interesting. But when we get to Angolan law, that is dealt with at paragraph 55 and 56 and 57 in across 3 pages of their skeleton. And it is a section of their skeleton that makes absolutely no reference, not a single reference, to the report of Professor Ribeiro. She doesn't feature in their skeleton. Instead, what they try to do is attack Professor Vicente's evidence, not by reference to Angolan law, but due to logic and analysis of words and so on. That, in my submission, is not going to work. And it fails on its own merits, on its own terms. For example, paragraph 56.3 of their report, of their skeleton, which is at page 35 of the core bundle, they pour cold water on the question of whether filing a joinder application needs to be decisive exercise of the company's capacity. They say that's irrelevant. The question, they say, is not whether the company has taken a decisive step as against the director, although it's not clear how they are feel able to make that statement, which is a question of Angolan law. Anyway, they say the question is whether the step results in a claim being brought, or will necessarily result in a claim being brought, or else barred, so that the situation as between the company and the director is no longer undefined. But we would submit that is exactly the result of making an application to join someone to proceedings, that the result of making that application is either that the person will be joined, or the claim will be barred. That's their, that is what they say the test is. It's not clear where they got it from. But that is satisfied by bringing an application for joinder. And furthermore, although they take issue with parts of Professor Vicente's report, they do not at all address the point about the provoked intervention under Article 356 and the statement in paragraph 16 of his report that I showed the court a moment ago. So that is a direct analogy with the current situation, which is uncontradicted by Professor Ribeiro, uncontradicted in their skeleton. We say that Professor Vicente's evidence is clear and compelling, that the obligation under Article 81 to file an indemnity action within 6 months of a resolution is satisfied by filing the application to join a party. It's not necessary to actually obtain the permission of the court for joinder. Filing a claim is a unilateral act of commitment to a legal process by a party, which is functionally equivalent to filing, which is functionally equivalent to whatever the necessary step in Angolan law. The filed claim may be rejected by the court immediately, just as an application for rejoinder may be rejected. But the necessary act has taken place within the 6-month period, and that is satisfied. Otherwise, if the relevant date was when the judge makes his or her order, one would have the curiosity that compliance with the 6-month time limit might depend on the vagaries of listing, how quickly the hearing could be brought on, the efficiency of the particular judge, and whether or not he or she gave his judgment immediately or reserved it, and so on. We would submit that on any view, we have a good arguable case that as a matter of Angolan law, the claim was not forfeit because the relevant step was taken within the relevant time. As I said at the beginning, if the Niedersachsen test is the correct test, then we have clearly put forward a case that's more than barely capable of serious argument. Indeed, that seemed to be the way, the only, seemed to be conceded in a sense in their notice of appeal. Can I just invite your lordship and your ladyships to look at that? It's in the core bundle behind tab 1 at page 15 of the grounds of appeal. So ground number 1 was that the judge was wrong to find that we had a good arguable case on the merits. And then they say to have a good arguable case, the claimant must show it has the better of the argument, or that the court cannot reach a case unless there's a, and so on. Ms. Dos Santos' case is that Unitel's claim is forfeit under Article 80. The judge should have concluded that he could say reliably that Ms. Dos Santos has the better of the argument on this issue, meaning Unitel does not have a good arguable case. In other words, their grounds of appeal were predicated on them succeeding on the test for what is or is not a good arguable case, although they have obviously developed that in their skeleton to run both an alternative argument that if they are wrong on the test, on the merits, that we lose. That is not the way they framed this appeal, and in our submission that is realistic of them. If they lose on the test, there's no sensible way they could win on satisfying this court that we don't have a good arguable case. But even if the court...
This argument was within the reasons that Lord Justice Arnold gave for granting permission.
Yes.
This isn't a point that they don't have leave to argue this point.
I'm not saying that. I'm not taking a formal point, but I'm saying that this reflects a realistic what's the realities of the situation. But even if the Court of Appeal does adopt the appellant's test for good arguable case, we will say we have certainly put forward a plausible evidential basis for our position in the sense that we have a prima facie well-reasoned expert report from a prima facie expert in Angolan law. There is a dispute fact here, given that Angolan law is a question of fact. and they have put forward a different report from a different expert. We would say that this court can actually take a view on the material available, given that Professor Vicente's report is well argued and supported, whereas her report contains 3 assertions plucked from the air. But anyway, if the court actually feels it can't form a reliable view on the material, which is a realistic position to take, then we satisfy the 3rd limb by way of the plausible, albeit contested material. in
Well, that's the
support
way
of
the
our
judge
reliable case.
decided in the alternative, isn't it?
Yes. So Mr. Justice Bright was correct. This court should give deference to his views, which were not plainly wrong, and in any event should come to the same conclusion as he did. My lords, my lady, we do have our respondent's notice, subsidiary arguments of the arguable case. I'm content to rest on what we said in our skeleton on that in paragraph 69 and 17. It may not be necessary to, I'm seeing, yeah.
I think that's probably wise, Mr. Speaker.
So, unless I can assist further on this point, those are my submissions.
Yeah, thank you very much.
My Lord, just a few brief bullet points by way of reply. At the outset of his submissions, my learned friend said that in the Niedersachsen, the court, Mr. Justice Mustel, gave the label good arguable case, or gave the merits test its own content. I'm going to respectfully suggest that that isn't what he was doing. I'll just give the reference. It's at Authorities Bundle 1, tab 8, page 79, G and H. One sees that in fact what he was doing was trying to interpret the corner case, as to which he said the case isn't easy to analyse, but it appears that the following propositions are justified. So one sees that in fact what he was trying to do in terms of giving content to the good arguable case merits test was by way of an analysis of corner. And the reference to my learned friend's submission is at page 75G of the transcript. The second point is that it's set against us that the approach for which we contend would increase the risk of mini trials. One might say that even on the Niedersachsen interpretation, if it's right that the merits are supposed to come back in again at the discretion stage, forgive me, there's already some degree of risk of mini trials arising from that, although, and I think this point cropped up in argument at the previous hearing, we say that there are strong reasons to doubt whether in reality the apparent strength of the case really does figure in the court's exercise of discretion, unless perhaps the perceived merits are very strong indeed. But it seems unlikely that where a claim has passed the good arguable case threshold, but only by a narrow margin, that's really something which will be weighed against the applicant at the discretionary stage. The next point is this. It was submitted that whereas jurisdiction is decided once and for all, freezing injunctions aren't, and that's why a higher merits threshold may be justified in the jurisdiction context. And I think Mr. G makes a similar point in his book as you were taken to. But the reality in practice, we say, is that freezing injunctions are granted until trial. It must be vanishingly rare for freezing injunctions to be discharged for a material change of circumstances between the initial grant of the order and trial.
I don't think that's the point that was being made with respect. I think the point that was being made, as I understood it, was that you're at a very early stage looking at the merits of the claim. That is an issue which will be determined at trial, the merits of the claim. Whereas when you're looking at the jurisdiction, when you're looking at the gateways for the purposes of jurisdiction, you're looking to see whether or not one or more of those gateways are satisfied. Once that is determined by the court, the reality is the court doesn't revisit that aspect the case at all. And that's not, that Gateway's test is not, in fact, the merits test, because the merits test is a separate one as to whether there's a good argument, whether there's a serious issue to be tried, a good argument case, whatever it is. Can't remember what it is now. You have to depose, don't you, that there is a sufficiently arguable case on the merits, and that's got nothing to do with whether you're in a gateway or not. No. So they're dealing with two, the point that's being made, seems to me, is that they're dealing with two completely different situations.
My Lord, I see that, and in fact, that's something which I think it was actually in response to a question from Lady Justice Falk that I think I did deal with. I was able to at the earlier hearing. So what it comes down to in terms of the principle in my submission is really this: is it right that if the court can't reliably say, that the court can reliably say that a defendant has the better of the argument, such that the judgment that the freezing order that's being sought is intended to protect is more likely than not never to be granted? Is it right in those circumstances to subject the defendant to the highly invasive freezing order regime, and we say it isn't? And then finally, quite a lot has been said about practical difficulties, not just in terms of mini trials, but more generally. We say that those submissions largely ignore the ability to fall back on limb 3 of Brownlee in the event that the court can't form a reliable conclusion, and to base its decision on there being a plausible evidential basis. That's all I was intending to say by way of reply, my Lord.
Thank you very much. Mr.
My lords, my lady, I don't accept what my learned friend says, that I can't say that Professor Vicente's evidence has changed. I would submit that that is clear from a reading of the reports. In his first report, as we showed you during the last hearing, he said very clearly that what is required is commencing judicial proceedings claiming damages from the director. He made absolutely no mention of the possibility of a joinder application. We then pointed out to them, at a point when they apparently didn't realise this, that if that's the case, this is a fundamental problem for the merits of their claim. And then suddenly, Professor Vicente's evidence, at the very least, was qualified by saying, no, in fact, there's another route through this. If you're in another jurisdiction, maybe another procedural step could be sufficient. And in fact, that procedural step could be exactly the procedural step which was taken in this case. So I make no apologies for saying that his evidence was changed. And in fact, it's very telling, we would say, that when my learned friend took you through Professor Vicente's evidence, he didn't even touch on his first report. He did not take you to his first report at all. So I would invite the court, when it's preparing its judgment, to go through those reports in sequence again and consider for itself whether or not that evidence has changed in a way that calls into question Professor Vicente's subsequent evidence. The overall thrust of my letter of friend submissions, as I understood it, was that there is functional equivalence between making an application for permission to bring a claim in Angola and making an application for permission to join a party and bring a claim in the context of an existing claim in England. My lords, my lady, that is wrong, and I'll explain exactly why. If I could take you to the supplemental bundle, tab 10. So this is supplemental bundle tab 10. This is Professor Vicente's supplementary report, and if we go on to page 110. starting at paragraph 23, my learned friend took you to this passage, I believe, briefly, but didn't spend much time on it. Professor Vicente says, the relevant procedural step in issue is the filing of an indemnity action. And he asks, well, what exactly should be understood as such for the purposes of that provision? And he starts with the position in Angola. He says, in Angola, this is at paragraph 24, in Angola, an action is deemed to have been filed once the claimant's initial application was received by the court at the court registry under Article 267. So this is vitally important. When in Angola, filing an application for permission to bring a claim means that under Article 267 you are treated as having brought a claim. It may be that that application is subsequently rejected, but that doesn't matter because under Article 267 you have brought a claim. As we know in this jurisdiction, if you file an application for permission to make a claim by way of amendment or by way of joinder, you aren't treated as having made that claim unless and until that application is granted, and then you go about actually filing and serving the amended claim. So there is no procedural equivalence between the position in Angola and the position in England. And that's clear on the face of Professor Vicente's own evidence. And so I don't accept, again, what my learned friend was at pains to emphasise, that just because this is a question of Angolan law, that therefore in some way it's not subject to the rigours of logical scrutiny. And I may say it's quite a striking submission to say that my expert report can't be subject to logical analysis, and that the only way of rebutting an expert report is to file expert evidence in return. And by way of explanation of why we didn't do that, for procedural reasons which we don't need to get into, the parties had already filed more expert evidence than would be typical in the context of an appeal. This was all done by way of ladder marshal applications. And so we took the view that it would test the court's patience even more if there was a fifth expert report. But also we took the view that it wasn't necessary because, as I say, just a mere reading of Professor Vicente's reports in sequence leads to the conclusion that his evidence has changed and that evidence is on its face, not credible. So there is no functional equivalence. Just picking up some of the other submissions that my learned friend made. He said that, he referred to my submission that when Professor Vicente uses the word respondent, he is using that word to mean defendant, as we would call it. That's at over the page in the supplemental bundle, page 111. And my learned friend is referring to paragraph 30. What matters for the purposes of Article 80 is the effect that, is that the effect of the procedural act performed by the claimant company be that of putting its director or former director in the position of respondent in judicial proceedings. It's clear that what he means by that is a defendant, because if you go back to paragraph 28, he refers to an amended claim is allowed, in which an amended claim is allowed for the compensation of that loss, so that a director or former director becomes a respondent in the proceedings. So when Professor Vicente is using the word respondent, he's using that term to mean a respondent to a claim for compensation. He's not using that phrase to mean a respondent to an application for permission to bring a claim for compensation. My learned friend said that he referred to Professor Vicente's evidence in his third report that you could bring a claim for a declaration and subsequently introduce a claim for damages by means of amendment. And I think if I understood my learned friend correctly, he was suggesting that the act of filing a claim for a declaration would be sufficient for the purposes of Article 80, because there's this prospect of filing a claim for damages or amending to introduce a claim for damages later. But if that really is my learned friend's position, and if that really is Professor Vicente's evidence, again, this is inherently implausible. Article 80 requires the filing of an action claiming damages. If Professor Vicente is saying that actually that can be met by filing a claim for something else, not including damages, that really would be a surprising position for Angolan law to take, and we say inherently implausible. My learned friend placed a considerable degree of emphasis on another aspect of Professor Vicente's third report. I'll just take you to it, page 136 in the supplemental bundle. And he placed a lot of emphasis on paragraph 16. And he said that in the final part of that paragraph, in the parentheses, he referred to the bit where Professor Vicente says, "This does not happen in Angola as just demonstrated. When an application is filed for a third party to intervene in pending proceedings, brackets, which if applied for in respect of a company director would be sufficient to satisfy Article 80 from the moment that application was filed." So, as I understood it, what my learned friend was saying was that this was Professor Vicente saying, if you file an application for the equivalent of joinder in Angola, then that would be sufficient for the purposes of Article 80 from the point of that application. And so that's a direct analogy to what we have here. Well, I mean, if that was right, I can see why my learned friend would rely upon it, but there is good reason to think that that is not right. And in particular, there are two reasons for that. The first is that if this was the answer, why is it tucked away in the parentheses of one of the final paragraphs of Professor Vicente's third report? If merely filing an application for permission to joinder was sufficient for the purpose of Article 80 and Angola, why wasn't that the first thing that Professor Vicente said? Because obviously that would be the closest analogy to our current case.
Well, that would be an excellent question for cross-examination.
Yes, but
that's the problem with all of this analysis, that it involves effectively going through these reports through the fine-tooth comb, saying, well, that doesn't look very convincing, this doesn't look very convincing, that can't be right. Well, you may be right at the end of the day, I don't know, but when you've cross-examined Professor Vicente, no doubt that will be quite apparent. But really, we are at a stage where there's a very limited merits threshold.
Well, my lord, that's the question. Is there a very limited
Well,
merits threshold?
on the assumption there's a very limited merits threshold.
Well, my lord, perhaps this is a good illustration of why there shouldn't be a very limited merits threshold.
On the contrary, Mr. Cooper, I suspect it's a very good reason for why there should be. Because otherwise we're going to end up with cases like this one, clogging up the business and property courts on contested freezing injunction applications in the exactly same way as we've got contested jurisdiction application, which have become the bane of the judges of first instance in all these courts.
Well, my lord,
what Lord Templeman said all those years ago about these, how it should be dealt with in the judge's room in half an hour or whatever it was, proved to be completely unrealistic. I mean, we've had in this court appeals which have lasted for several days from jurisdiction challenges, which in turn have lasted for about 3 or 4 days in either in the business list or in the commercial court. And you know, the idea that that's going to happen in freezing injunction cases as well is pretty horrifying.
well, my lord, if I may, can I seek to persuade you on that subject? This is not a jurisdiction application. There are other ways of resolving the dilemma that you've described in respect of jurisdiction applications, such as what they've done in the BVI, which is saying you don't actually need to seek permission prospectively to serve out. The other side has to come back and challenge service out once they've already been served, and that would alleviate a lot of the burden that you're describing. But anyway, there seems to be an assumption on the part of some commentators and indeed on the part of my learned friend that having heavy contested applications of freezing injunctions is undesirable. But my lord, that's, frankly, we disagree. This is the most, or maybe the Anton Pyler relief, this is the most invasive interim relief that can be granted by this court. and it's granted for the purposes of protecting a judgment. Now, if it's the case that that judgment in reality is not going to transpire, then what's happened is a person has had their property rights interfered with extensively, potentially for years, in support of an injunction that should, for no reason, wrongly. Now, of course, it may be said, well, that's fine, there's the cross-undertaking and damages, but we all know that proving loss on the cross-undertaking and damages is extremely difficult. And in any event, damages doesn't compensate a person properly for the interference with their free dealing with their property. It only compensates them for loss that has been arisen as a result of their interference with free dealing with their property. If there's any interim application which justifies more extensive scrutiny of the merits, it's this one, a freezing injunction.
Well, you're moving away now from dealing with young girl and law evidence into really repeating what Mr. Margolin has already submitted. You said there were two reasons why what Professor
Yes.
Vicente said in paragraph 16 couldn't be right. One was that if that were the answer, why was it tucked away in the third report in parentheses? What's the other one?
Yes, the other one is that Professor Vicente has provided absolutely no explanation for why indeed it would be the case that applying in this manner would be sufficient for the purposes of Article 18. My learned friend criticised our expert for supposedly providing insufficient analysis, but if there's any example of a bare statement without analysis, it's this one.
Yeah.
I've already dealt with why we didn't put in an expert report in response to this one.
Much at that point.
Pardon me, my lord?
I don't think much at that point. We'd have had another 4 experts' reports if you had to produce a response.
Quite.
It'd go on forever.
Indeed. And as I say, my learned friend's submission seems to be premised on the idea that his expert reports can't be subject to logical scrutiny, which we don't accept. My learned friend says that if you bring an application for joinder in this jurisdiction and that fails, then the claim is barred. That's wrong. If you bring an application for joinder in this jurisdiction and it fails, you can bring a fresh action. And you can bring a fresh action and then seek consolidation, if necessary. Indeed, that is sometimes done precisely to avoid the danger that my learned friend has found himself in, which is that you can't get your joinder application heard in time to come within the time limit.
Mm-hmm.
Then my learned friend says that, well, it would be surprising if the step that Unitel was required to take was the making of a claim as opposed to just the filing of something, because as he says, if you try to make a claim by way of joinder, then you're subject to the vagaries of listing. But 2 points in response to that. One is you don't have to apply for joinder, as I say, you can issue a fresh claim. And the second is, in fact, that danger is exactly what happens in England. So if you issue an application for joinder in England before the limitation period has expired, but then that application is not actually heard until after the limitation period has expired, you're still subject to the requirements of CPR 19.6. I can see my Lord Justice Popplewell nodding to that, so I won't necessarily take you to the authority, but if authority is required for that proposition, it's the Welsh Development case, which is at tab 10, page 100. My Lord the Chancellor, would you like to turn that up? Tab 10, page 140 of your joint authorities, my Lord.
Yeah.
So if you're at page 140 at the bottom of the page, the judge held that the time at which one assesses whether a limitation period has passed is the date of the hearing, and the appellant disagreed with that. He said that no, it should be the relevant date. The relevant date should be the date that the application was made. And if you go over the page to pardon me, I'll just turn that up. Yeah, so bottom of the page is where the submission was put, that it should be the date of when the application is made. And the justification over page 141, the justification given for that was very similar to what my learned friend has just said. Said at B, otherwise the plaintiff's right to amend would depend, I'm quoting, would depend on purely arbitrary factors such as when the court could hear the application for leave or how long it took the court to deliver judgment after the application. But the Court of Appeal said, well, yes, that's exactly what happens. If you want to avoid this, you should issue a fresh action. It says, and this is underneath C. Well, and the court can read it beginning within our judgment.
That's
Yeah.
based on the interpretation of the legislation.
Indeed, but all I'm saying is that it's not an inherently surprising or unjust outcome that the date should be the date that a claim is actually treated as having been made, as opposed to the date of application.
Right.
Because, I mean, if it was inherently unjust, it would be surprising if that was the position in England, which it is. But stepping back, the consequence of my learned friend's position is that a claimant could apply for joinder, that application could be dismissed, or they could never take up the permission that they've been given, and he then succeeds in stopping time for the purposes of Article 80, but then just shelves the claim. And he, in theory, the claimant could shelve that claim all the way up until the expiry of the 5-year limitation period. Recording that forfeiture periods and limitation periods are different in Angola. Now, that cannot be right. It cannot be right in that a provision which aims to ensure legal certainty and security and clarity for the defendant can be satisfied by doing a step that would actually allow the claimant to shelve the claim. It's the very opposite of the point of this provision.
What in this country is the separate step of taking up the permission? Normally what happens is you produce a draft amendment, you apply for permission. If permission is granted, that's it, it's in. You don't do something separate, do you?
My lord, no, you have to file and serve the amended claim form. So there's 2 steps. This may actually be crucial because, as I say, that's not the position in Angola. In Angola, if you file the application for permission to bring a claim, that step in and of itself is treated, as we just saw under Article, I think it was 267 of the Angolan Civil Procedure Code, as the bringing of a claim. Whereas in this case, or in England, you file an application for joinder, it's granted. You then have to do something. You have to actively decide to take up the permission that's been given to you by filing or serving.
Although what we saw in Welsh Development Agency left open the question as to whether it was the granting of the permission that would stop time running. I think they said not earlier than the
Not
moment
earlier.
at which the
Yes, I mean, there is another case in which deals with this exact question, admittedly in the context of the English Limitation Act, which I can take you to, and it's decided that it's called Butters and Hayes. It's in our supplementary authorities bundle.
it's the filing, is it?
It's actually the filing or serving, whichever is earlier, is what
Okay.
is the, in fact, perhaps I can.
Don't worry, we can look at that.
Okay. I was wondering, do you mind if I just have 2 minutes to look through my notes and make sure that I haven't missed anything?
Yes, of course.
My lords, my lady, nothing further from me.
Thank you very much. Right.
So turning to the costs appeal. I'm proposing to start with the authorities. I'll then show you how the judge dealt with this question. I hope that by doing things in that order, it will become clear why we say with respect the judge fell into error. In summary, what the authorities show is that because interlocutory injunctions are granted not on the basis of a final determination of the merits, but as a precaution in case the claimant goes on to obtain judgment. Whether the claimant does in fact obtain judgment is a relevant factor which should be taken into account when determining whether the defendant should pay the claimant's cost of the application. And so the usual and proper order in relation to interlocutory injunctions generally is that costs should be reserved to the trial judge. We say that those principles apply just as strongly in the context of freezing injunctions as they do in the American cyanamide context. To be clear, we're not saying that there's any rule requiring that the costs of contested hearings over freezing orders be reserved, as it's put in my learned friend's skeleton argument. What we say is that that's the usual order, or should be the usual order, absent any special factors, and in this case there were no such special factors. So the first case is a case called Descaines et Girard and Richardson. It's in Authorities Volume 1 behind tab 13. And the judgment was given in November 1999, so that's just a few months after the CPR came into force.
Sorry,
Tab 13, page 176 of the first volume. And this was an American cyanamide injunction to restrain breach of a non-competition covenant in an employment contract. The injunction had been continued following a contested hearing. The judge at first instance had held that costs should follow the event, and the question on appeal was whether he was right to do so. And if one can go please to page 181. Right at the bottom of the page, paragraph 12, Lord Justice Moritz said, "I accept, of course, that the issue was one for the judge's discretion. In my view, this is one of those cases where this court is entitled and indeed bound to interfere with that exercise. I say so for basically three reasons. So the first reason, he says, is that the decision seems to me to be inherently unjust. It's quite plain from the passage in the judge's judgment from which I quoted that he granted or continued the injunction, I should say, on the basis of the balance of convenience in order to hold the ring until the dispute between the parties could be properly decided at a trial. It's inconsistent with an order such as that there should be successful or unsuccessful parties for the purposes of the rules, either new or old." Just pausing there, the significance of the injunction being continued on the basis of the balance of convenience is simply that it wasn't continued on the basis of a final determination of the merits. We say that there was no attempt being made there by the Court of Appeal to draw a distinction between injunctions granted on the balance of convenience and injunctions granted by reference to another test. The real point was that the test didn't involve establishing your right on the balance of probabilities at trial. And one, in fact, sees that really from the second reason given at paragraph 13. Second, it seems to me that the judge was wrong, therefore, in determining, for the purposes of Rule 44.3.2, that either Mr. Richardson was the unsuccessful party or alternatively that the employer was the successful party. He was right to consider within the terms of that rule whether to make an order about costs. That was what he did, but the order that he made was, going back to Rule 44.3.1a, whether the cost should be made payable by one party to another. That seems to me to have been wrong. There were no successful or unsuccessful parties at that stage, and the proper orders to be considered were those under the terms of the practice direction. And then the third reason given in paragraph 14 related to the judge's reliance on the rules in favour of summary assessment over detailed assessment, which isn't our concern. So that's, as I say, a case decided not long after the introduction of the civil procedure rules, and one can understand why, perhaps in those circumstances, the new rules about identifying successful parties and unsuccessful parties were thought to be in play. The next case is at the next tab 14.
Can we tell, sorry, before you move on, can we tell what the scope of the dispute was before the judge in that case, which may largely have been whether there should or shouldn't be a preliminary hearing. Well, Justice Moritz said it's a case in which you couldn't treat either party as successful or unsuccessful. Maybe
Well, but
the key to it, but that rather depends on the particular facts as to what was and wasn't being argued.
well, one can see from the bottom of page 177 and the top of 178 what seems to have been in play, and it was a continuation of an injunction, and the judge found that there was a strong arguable case as to the existence of confidential information requiring protection, and as I say, there were issues about the applicability of a particular covenant in relation to confidential information. I think the point about successful and unsuccessful parties was, as I respectfully submit, one gets this from the language in paragraph 13, there were no successful or unsuccessful parties at that stage, and that's because it would only be at trial that it would be established who'd won and who'd lost. In fact, the whole of the language of paragraph 13 in my submission gives that strong impression.
Thank you.
So if one then goes, please, to Picnic at Ascot behind tab 14,
Yeah.
this was another American cyanamide case. As one can see from the head note, undertakings were offered at the first hearing in September 1999 until the substantive hearing of the application, which was refixed for the 8th and 9th of February 2000. On the 2nd of February 2000, the defendants said that they wouldn't contest the application and that they were prepared for the undertakings to remain in place until trial or further order, and they proposed that costs be reserved to the trial judge, but the claimant applicant pressed for its costs. If one could go, please, to page 185, paragraph 5, right at the bottom of the page. Says the question then is, it should be the question then is, what approach should the court take to the question of costs in the case of an application for an interim injunction when that injunction is granted or when the defendants accede to the injunction being granted? It seems to me that the following guidance could be obtained from the cases to which I've been referred. And then paragraph 7.1, in a case without any other special factors, where a claimant obtains an interlocutory injunction on the basis of the balance of convenience, the court normally reserves the costs. While one can see an argument, particularly under the new regime, for saying that an order more favourable to the claimant should be made on the basis that the claimant has won the issue in respect of which the costs have been directly incurred, namely whether an interlocutory injunction should be granted or not. It seems to me that the reasoning of the Court of Appeal in the so far unreported case of Dick Kane indicates that an order reserving the costs is appropriate. And again, the reference there to the balance of convenience, we say, is just being used in contradistinction to injunctions based on findings of fact on the merits. And the judge then goes through Dick Kane. At the bottom of that page, in paragraph 9, he says one can see the force of that, particularly when one bears in mind that the balance of convenience will often be determined by reference to facts which may be contested, and the court may at trial conclude that it had been persuaded to grant an interlocutory injunction on the basis of assumed facts which turn out to be inaccurate, or even in the context of a claim which should never have been brought. Now, of course, we're dealing with freezing injunctions. They're not granted on the basis of the balance of convenience, but that doesn't alter the fact that the court may still conclude at trial that it had been persuaded to grant an injunction at an interim stage on the basis of facts which turned out to be inaccurate, or even indeed in support of a claim which should never have been brought. So that the reasoning holds good, we say, in the freezing injunction context as well. If one then looks at paragraph 10, the judge said, as this present issue concerns the question of cost, it would plainly be wrong to treat Richardson, even bearing in mind that it's a recent decision of the Court of Appeal, as authority which ties the court's hands when it comes to the question of costs in a case such as this. However, in my view, it's plainly undesirable that there should be inconsistency of approach to questions of costs between different courts. This is especially true when one bears in mind what was said as long ago as 1990 about costs by Mr. Justice Hoffman in Kickers. This is a dispute over costs. At one time, it might have been said that it was only about costs, but litigation has become so expensive that there is no only about costs anymore. The ruling on costs can easily be the most important decision in the case. Paragraph 11 is then specific to cases where an injunction's been conceded. And then in paragraph 12, the point's made that obviously there'll be circumstances where it's right to depart from the general approach. The judge seems to have thought that this was such a case, and I'll say something about that when we come back to look at the judge's reasoning in relation to those factors. If we could go now, please, to volume 3 of the authorities. My lords, my lady, you should find behind tab 31 a case called Bravo and Amerisor Resources. So we've seen 2 cases decided in 1999 and 2000. One then has to fast forward some 20 years before anyone suggests that that reasoning shouldn't also apply in the context of freezing injunctions. And if I could
So
ask,
sorry, I missed the reference. Where are we?
forgive me, it's behind tab 31, volume 3, page 663 and following.
Thank you.
If I could ask you, please, my lords, my lady, to go to page 677. In paragraph 46, the judge records that the parties have agreed that costs are in the discretion of the court, and then he says a point of principle which arises between the parties.
Sorry, where are you?
Sorry, paragraph 46, bottom of page 677. So he says that a point of principle which arises between the parties is whether this is an application which is akin to normal interim injunctions, where the court makes assumptions on the facts and also makes reference to the balance of convenience, both of which may at the final hearing be considered quite differently when the full evidence and trial has been heard, so that it's appropriate to reserve the cost so that the position when the interim injunction was made can be viewed retrospectively in the light of the matters which have emerged at trial and in respect of which the court has made its adjudication, or whether applications for freezing orders are a discrete form of order upon grounds which are not susceptible to significant re-evaluation at trial, so that an order for costs can and should be made in relation to the freezing injunction rather than await the outcome of the trial. He says there's surprisingly little authority on that. If we pick it up over on page 679, paragraph 49, the judge refers to the passage in Picnic at Ascot, where Mr. Justice Neuberger talks about bearing in mind the balance of convenience will often be determined by reference to facts which may be contested. And then if one goes to the bottom, please, of that page, paragraph 52, the judge said, it seems to me that this is enough to show that the decision in Picnic at Ascot is not wholly apposite in claims for freezing orders, where the balance of convenience is not an issue, and where in relation to the merits of the case, the court has regard to the question of whether there's a good arguable case on behalf of the claimants or not. That's sufficient for the court to determine whether a freezing order should be made. And even if at the subsequent trial it turns out that the claims fail on the basis of the evidence due to that trial, it does not at all follow that this means that the court was wrong to find that there was a good arguable case. On the contrary, those two findings are wholly consistent with each other, or may be wholly consistent with each other, nor is there any reference to the balance of convenience. The question is whether it's just and convenient to make an order. Pausing there, we say with respect, there are a number of difficulties with that approach. First of all, it's obviously correct that the judge could be right to conclude that a claimant has a good arguable case, but the claimant nevertheless ends up failing at trial. But that's not a point of distinction between freezing orders and American cyanamide cases is there too. The judge dealing with the interlocutory application could be right to conclude that the claimant has a serious issue to be tried, but again, the claimant might still be unsuccessful at trial. So the position is, for practical purposes, the same. Then the reason why the court generally reserves costs in interim injunction cases is because facts may emerge at trial which mean that with the benefit of hindsight, it was wrong to grant the injunction, either because it transpires that the claimant's claim was bad, or because the balance of convenience wasn't as the court thought it was. Although, of course, the grant of an interim injunction may involve consideration of questions of the balance of convenience which are not relevant at the trial and therefore aren't reconsidered at that stage. It's just as possible for a court to conclude following trial that with hindsight, the court was wrong to grant a freezing injunction, either because the claim was a bad one or because there wasn't in reality a real risk of dissipation. In this regard, it's important to remember that real risk of dissipation is, as in this case, often founded in part, quite possibly to a very considerable extent, on the notion that the claimant has a good arguable case and on the character of the claim. So the fact that the test is different in freezing injunction cases, good arguable case, rather than serious issues to be tried, we say with respect is just irrelevant. And beyond that, as some of the discussion at the hearing in June hinted at, there may obviously be questions as to the extent to which those tests, good arguable case and serious issues to be tried as understood nowadays, are different. It may be that one's dealing with a sort of sliding scale, but there's certainly no bright line distinction between those two tests that means that some different approach to cost should be taken in freezing injunction cases from American cyanamide cases. So going on to paragraph 53 on the same page, the judge said he agreed with counsel that the regime for the making of freezing orders is different to the general position where interim injunctions are sought based upon balance of convenience and holding the ring pending trial. There are obviously overlapping features, holding the ring being one of them. The purpose of a freezing injunction is to avoid a successful claimant being unable to enjoy the fruits of his success because there are no assets left against which the judgment can be enforced, but that's a different kind of holding of the ring to that which is involved in the usual interim injunction and balance of convenience type case. Again, we say with respect, that's just not a relevant distinction. All interim injunctions aim to prevent someone from doing something that it may transpire he or she ought not to have done. The fact that in a freezing injunction context, that something is dealing with assets in a way that will make them more difficult to enforce against is, we say, for the purposes of this cost analysis, neither here nor there. And on the basis of that reasoning, the judge then made an order for costs. If we can go to the next case, which is at the next tab, tab 32, beginning at page 683. The next case in the bundle and the next in time is Melford Capital Partners and Wingfield Digby. A Court of Appeal decision from December 2020. Now, this was an American cyanamide case, but Bravo and Amerisor, as one sees from the very bottom of page 683, was cited to the court. Essentially, an application had been made for an injunction without notice, and the injunction was granted and then continued on the return date, albeit without opposition, and the judge at first instance ordered costs in the case. If I could ask your lordships or lady to go to page 692. In paragraph 31, one sees at G that the judge at first instance had said that those decisions, that's referring to Dicken and to Picnic at Ascot, those decisions were made shortly after the CPR came into force. I suspect the reality is that those two cases have been overtaken, I would say for some years, by the modern approach to costs under the civil procedure rules. In the end, of course, it's a matter for the court's discretion, and that approach was challenged on appeal. If one goes, please, to page 694, top of the page, paragraph 35, we were taken to the authorities. As we've noted, the judge referred to Dicken and Picnic at Ascot. Of these two cases, the editors of Civil Procedure 2020, the White Book, at paragraph 44.6.1 say, where an interim injunction is granted, the court will normally reserve the cost of the application until the determination of the substantive issue, it can. However, the court's hands are not tied, and if special factors are present, an order for cost may be made and those costs summarily assessed, picnic at Ascot. Paragraph 36, in our judgment, that short passage accurately represents the law. We were referred by the respondents to cases in which different orders have been made. And one of those cases that they were referred to, as I say, seems to have been Bravo and Amerison. But we do not consider that those cases undermine the statement of the general rule in the White Book as decided by the two cases. Paragraph 37, we set out below certain parts of the two main cases on this topic, Dicken and Picnic at Ascot, that with respect we consider helpful in considering the exercise of the discretion in this type of case. The other cases to which we referred are, in our view, only examples of the courts either following the general rule or taking a different course on the facts of individual cases, but we didn't find any that provided any significant gloss upon the principles to be applied. And then this is important, we do not accept that the so-called pay-as-you-go principle has precedence over the decision in the Dicken case in proceedings for interim injunctions. And then one sees in the following paragraph, 6 lines down, on the contrary, the Dicken case is an authority of this court as to the normal approach to the question of costs of an application for an interim injunction where the grant of the injunction turns on the balance of convenience. As Picnic at Ascot rightly states, the court's hand isn't tied to that normal order, and special factors may call for an order for immediate payment of costs or part of the costs. However, the judge didn't identify any such material special factors in this case, apart from his judgment as to who'd been the successful party on the injunction application. In our view, he was wrong to draw the contrast with the provisions of the civil procedure rules that normally require payment of costs by the unsuccessful party. As Dicken shows, the CPR rule upon which the judge drew cannot be directly applied in proceedings of this type. And then paragraph 39, this is an important point, the quest for the successful and unsuccessful party in such cases is usually fruitless. And then if we go to the following page, paragraph 41, please. Essentially, as recorded in the first sentence of that paragraph, the claimant argued that he got what he came for. But the Court of Appeal says that's not the point, and this is just below C. Whenever a claimant successfully seeks an interim injunction preventing the defendant from doing something, whether using a right of way, working for a competitor, or infringing a patent, the defendant will be stopped from doing whatever it is for the time being. That was precisely the case in both Dicken and Picnic at Ascot. However, the judge's decision that he was unable to resolve the merits of the disputes means that the basis on which those orders were obtained and continued, without objection from the appellant, may prove in the end to have been unfounded. Success of this type is only a provisional one. On the other hand, a costs reserved order doesn't mean that the claimants generally, or these respondents in particular, will never recover the proper proportion, if not all, of their claimed costs. The matter is open, and the costs have been neither won nor lost by either side at this stage. And my lords, my lady, this is absolutely fundamental. The mere fact that you got the injunction that you applied for does not mean that you're entitled to be regarded as the successful party in terms of Part 44, because in the end it may transpire that with hindsight, the basis on which the injunction was granted was unfounded, and the injunction shouldn't have been made. And that's a point which we'll come back to in one of the other authorities very shortly. My lords, my lady, can I ask you to go now, please, to tab 37, the case of Kumar and Sharma, Sakamaka 2, beginning on page 835. This was a freezing injunction case where there was a without notice hearing and then a return date. The judge, deputy judge, decided to follow Bravo and Amerisor, and I'd ask your lordships, your ladyship, to note Melford Capital doesn't appear to have been cited. Certainly it's not listed in the cases cited on page 836. And if one goes, please, to paragraph 3 on page 837, one sees the learned deputy judge asking himself, I take first the question of whether costs should be reserved to the trial judge or alternatively be in the case on one hand, compared to being dealt with now on the other. There's a body of authority that freezing orders are slightly different to other interim injunctions in this regard. And he refers to Bravo and Verisio, Darnitzer and Rosler. And his reasons are on page 839 in paragraph 12. First of all, he said, as explained in Bravo and as submitted by counsel, that freezing order does not hold the ring in the same sense as other types of freezing injunction do. But, and this is a point I've made already, with respect, it does, we say, so far as relevant. In both cases, the claimant's asking the court to interfere with the defendant's freedom of action on a basis that it has a claim, although that claim may ultimately turn out to be a bad one. Second, it's a choice for a defendant as to whether to resist the continuance of a freezing order and cause the cost of the return date to be incurred. Well, that, of course, is equally true in an American cyanamide case, so that's irrelevant as a point of distinction. Three, there are clear tests for whether a freezing order should be granted and continued, and those are different to the test for whether the claim should succeed at trial. But, of course, the test for an American cyanamide injunction is also different from the test for whether the claim should succeed at trial. So, again, that's not a distinction between freezing orders and cyanamide injunctions. Four, it follows that it's possible to tell in most cases who the winner and loser is on a return date in a way that it is often not on an interim injunction that truly holds the ring on an interim basis until trial. Well, with respect, we say that's just wrong. Just as a judge doesn't determine the claim on the merits on an ordinary American cyanamide injunction application, nor does he or she determine the claim on the merits on a freezing injunction application. And again, it's not therefore possible to say who the winner is. The position is really no different from an American cyanamide injunction, where again, it will be clear whether the applicant has obtained the relief sought on his application, but it doesn't follow that the claimant is properly to be regarded as the successful party for the purposes of what is now CPR 42.22. Five, therefore, the fact that here the evidence relating to good arguable case will overlap or be the same as the evidence relevant to trial to whether the claim succeeds on the facts is not, to my mind, decisive. If the defendant chooses to oppose the continuation of the freezing order, it needs to prevent the claimant demonstrating that there's a good arguable case. If that's the ground of challenge, it chooses to mount on the return date. And if the defendant fails, then it's failed on the return date on that element of the case, irrespective with the reasoning in Bravo. Well, it is consistent with Bravo, but it's completely inconsistent in my submission with the Court of Appeal's decision in Melford Capital, which makes it clear that getting the interim injunction you want without more doesn't mean that you're entitled to your costs in any event of that application. Six, by analogy, where, for example, a defendant brings an application for reverse summary judgment against the claimant and fails, it's no answer to the claimant's claim for costs that the defendant may ultimately be the successful party at trial on the balance of probabilities. Well, with respect, we say that that's not a reliable analogy. In fact, it's not an analogy at all. The distinctive feature of an injunction is that you're asking the court to prevent the other party from doing something in case you succeed at trial. If you don't then win at trial, then with hindsight, that restriction on the other party's conduct ought not to have been imposed, and you shouldn't get your costs of obtaining it. A fortiori, one might say, in relation to so intrusive an interim remedy as a freezing order. If a defendant applies for reverse summary judgment and fails, that doesn't result in the claimant being subject to any restraints that might prove with hindsight to have been unjustified. And again, we'll touch on this when we come to the Al-Assam case, but His Honour Judge Davis White, King's Counsel in Al-Assam, said in relation to that, the analogy isn't an apt one. A reverse summary judgment application is determined once and for all. It's not in any sense an interim decision that holds the fort until trial in any sense. Paragraph 7, bottom of 839, indeed, were it otherwise, a defendant would have a free shot at opposing a freezing order continuance on a return date on the good argument case ground, knowing that it would not have to bear costs if it ultimately succeeded at trial, or unless and until the trial took place and had been decided. Well, 2 points on that. First of all, it's not a free shot, because the trial judge may well decide that the defendant should pay the claimant's costs. But in any event, precisely the same argument can be made in respect of American cyanamide cases. So it's not a distinction between freezing orders and other interim injunctions. 8, I'm able to deal with issues of full and frank disclosure and the duty of fair presentation now, and to my mind, I'm in a considerably better position to do so than the trial judge. Well, that doesn't arise in this case because the application for the freezing order here was made on notice. And then paragraph 9 is specific to the facts of that case. So to summarise, with respect, we say none of the reasons given by Mr. Hilliard, King's Counsel, is a good reason why a different approach should apply in freezing injunction cases from that which applies in American cyanamide cases. If I could ask you please to go to the next tab 38. This is the Al-Assam case, the decision of His Honour Judge Davis White, King's Counsel. And this is the case, and it was a freezing injunction case, where we say the court got it right, and at the end of the return date, the judge ordered costs reserved. The analysis in relation to costs begins on page 884. And this is where the judge explains why he made that order. Paragraph 223. In the case of interim or interlocutory injunctions, the starting position is now well established that the cost of the application will usually be reserved, though there may be factors, or as it's been put, special factors, which I do not consider to amount to exceptional factors, justifying some of the costs order. And then he refers to Dick Hen, Picnic at Ascot, and Melford Capital Partners. And he talks about in 224 what special factors may involve, and he goes through various cases, including those which we've already looked at. And if we can go please to page 890, this is the section of his judgment on this headed discussion. He sets out the respective tests for American cyanamide injunctions and freezing injunctions. And then in 251, he says in both American cyanamide applications and freezing order applications, although I accept with slightly different effect on operation, the effect of the order is to hold the ring. If the applicant in either case loses on the merits at trial, then the interim injunction will be discharged. Indeed, in such circumstances, an inquiry as to damages may be ordered on the cross undertaking, usually given by the applicant for the original interim order. Next paragraph. As regards interim injunctions granted under the American cyanamide principle, it's no answer to an application for the cost of the application to be reserved to say that the respondent failed to establish that there wasn't a serious issue to be tried, and that whatever the position at trial, the respondent has failed on the assessment of the merits test as they stand and apply at the interim stage. Indeed, that was the flawed approach adopted in cases such as Melford Capital Partners. The reason is because the claim has not then been established. In my judgment, the same is true in principle as regards a freezing injunction. The court has simply decided that there's an arguable claim, not that the claim succeeds. If the claim fails at trial, then the freezing injunction should, with the benefit of hindsight, not have been made, and we say that's exactly right. Down at the bottom of that page in paragraph 254, the learned judge says, once one gets to the balance of convenience under the American cyanamide test, it's because there is a serious issue to be tried. The question of the balance of convenience is in many cases not revisited at trial. It's the merits of the underlying claim which are definitely revisited. I do, of course, accept that features considered under the heading balance of convenience may have further light thrown upon them by the trial process and decision. The passage in Mr. Justice Newberger's judgment that I've cited refers not only to the trial shining a light on factors that go to the balance of convenience, but also the possibility that it demonstrates that the claim should not have been brought. This confirms my view that the merits not being determined is a reason why costs are usually reserved, at least as a starting point. There's also the following passage in his judgment, which appears to me to apply equally to the making of freezing injunctions. If the court's faced with disputed facts and believes the claimant's version of the facts is more likely to be accepted, it may be dangerous to take that into account in the claimant's favour when deciding what to do about costs. It's obviously conceivable that at trial the court's preliminary, even its strongly held view as to the likely outcome of the dispute on fact may turn out to be wrong. It would be adding insult to injury if an unfavourable order for costs is made against the defendant in addition to the injunction being granted at the interlocutory stage on the basis of a wrong, as it turned out, view of the facts by the court. I do not see that statement as limited to disputes of facts regarding balance of convenience issues. Consider that it also encompasses disputes as to the underlying claim itself. In any case, on the facts of this case, the trial is going to shed light on the risk of dissipation because that risk is largely founded upon the causes of action, or at least the facts asserted in support of them. This is likely to be the case in many situations. And if one goes, please, to paragraph 258 at the bottom of that page, towards the end of the third line, the judge says, in short, the tests under American cyanamide and for a freezing order are different, but in my view, they're sufficiently analogous and sufficiently dealing with the same position that the starting cost position should be the same, notwithstanding A, the tests are in slightly different terms, and B, the holding of the ring is in a slightly different manner. So far as it's suggested that in a freezing injunction application that succeeds, the court can say who has won, the answer is that at that stage the court cannot say who has won. The decision is interim, and we say with respect, my lords, my lady, that analysis is exactly right. The basis on which costs are reserved in interim injunction cases is that the merits aren't being finally determined. It may transpire that the claim is bad, and therefore, with hindsight, the claimant shouldn't have got the protection it obtained. Exactly the same is true in freezing injunction cases, and so the same principles we say, with respect, should apply. Unfortunately, in spite of that very clear, and we respectfully submit, cogent reasoning, that decision wasn't followed in the next case, which is at tab 40. So this is Authorities Volume 4, tab 40, beginning at page 1007.
This is Harrington.
This is Harrington and Charles. That's right, my lord.
Yeah.
I mentioned in passing this was an extempore judgment, whereas Al-Assam was a reserved judgment. We don't place enormous weight on that, but Mr. Justice Edwin Johnson himself said in this case that he saw some force in the notion that reserved judgment might be thought to carry more weight than an extempore judgment, at least where a decision has had to be made in a hurry. But
Yeah.
passing on from that, if we could go please to page 1011, one sees that this starts with a discussion of CPR 44.2. There's a reference in paragraph 13 to the Al-Assam case we've just been looking at. One sees that there's then a consideration in the context of looking at Al-Assam of the various cases that were referred to by Judge Davis White in Al-Assam. And if one then goes, please, to page 1014, right at the bottom of the page, paragraph 26. Mr. Justice Edwin Johnson says he had the misfortune to disagree with the utmost respect with the reasoning of Judge Davis White in the relevant part of his judgment in Al-Assam. I say this for two reasons, one of which is of general relevance, one of which is specific to this case. And the general reason is specified in paragraph 27 at the top of page 1015. It seems to me that while it's correct to say that a freezing order holds the ring, it also seems to me that it's correct to say, and I accept the submission of Mr. McQuaid in this respect, that a freezing order holds the ring in a different way, in my judgment in a substantially different way to an interim injunction. As Mr. McQuaid pointed out, in the case of an interim injunction, what's generally happening is that the court is allowing one party to enforce or rely on a right or an obligation, the existence of which has yet to be established. So in that sense, the court is allowing one party to behave as if the right had been established in circumstances where the right still has to be established at trial and may not be established at trial. In the case of a freezing order, things are rather different. The freezing order, as Mr. Grant quite correctly pointed out, is an ancillary order in aid of the relief which is sought in the relevant case. There's no such thing as a final freezing order. Once the freezing order has been granted and subject to any subsequent application to vary or discharge, the freezing order then remains in place until trial. It may well be that the freezing order is obtained on a basis which is found not to be well founded at trial, but that, it seems to me, does not go directly to the question of whether the freezing order was correctly granted. Rather, it relates to the underlying relief which is sought. In relation to the freezing order, it seems to me that what happens if the claim fails at trial is that the freezing order is no longer required to hold the ring because there are no assets to be protected or ring-fenced, because there is no right of recovery. But with respect, my lords, my lady, we say that that analysis is confused. An application for a freezing order is also relying on a right that he has yet to establish, the right to restrict a person's dealing with his or her own assets. The fact that this right won't be established even at trial, but only once one goes yet further down the line to the enforcement stage, we say is neither here nor there in terms of drawing a contradistinction between cyanamide cases and freezing orders. Fundamentally, all interim injunctions, including freezing injunctions, involve an interference with the defendant or his or her assets. That interference is justified on the basis that the claimant may in the end obtain judgment, but if the claimant doesn't in the event obtain judgment, then with hindsight, that interference with the defendant or his assets was wrongly granted, and so the defendant shouldn't have to pay the claimant's costs. If one then goes to the bottom of that page where we were, paragraph 31, I find compelling what was said by Mr. Justice Martin Spencer in the Bravo case, also paragraph 32 at the bottom of page 1016. He also agreed with the reasoning of Mr. Hilliard in Kumar and Sharma. And then over on 1017, paragraph 33, he says he agrees with Mr. Hilliard's free shot argument. That is that if costs are reserved, this will incentivize defendants to resist injunctions even when the merits are poor. But of course, on that logic, you wouldn't reserve costs of contested interim injunctions, including in American cyanamide cases. And as I've already submitted, it's not really a free shot, because if costs are reserved, the applicant may well end up being able to recover those costs pursuant to the order of the trial judge. Paragraph 40 and 41 on page 1019, Mr. Justice Edwin Johnson refers to Melford Capital Parties, and he says it's a decision of the Court of Appeal which binds me. And that case is authority for the general rule that in the case of interim injunctions, the cost should be reserved. But 41, he says that wasn't considering the position in relation to freezing orders, and accordingly, I don't regard it as a decision which binds me in dealing with the discharge applications or the continuation application. Whether that's technically right or not isn't relevant, we say, because the reasoning should apply equally in our respect for submission to freezing injunction cases. And then paragraph 48, I just mentioned the point I've already trailed about extempore judgments and reserve judgments. The next case, finally on the English authorities, although strictly this is a Privy Council appeal from the Court of Appeal of the British Virgin Islands. My learned friends rely on the Privy Council's decision in Convoy Collateral, exactly, which is at volume 3 behind tab 36. And as the court may recall, one of the questions the board had to grapple with was whether to obtain a freezing injunction, an applicant had to have an existing cause of action. In answering that question, the board considered the purpose of a freezing injunction, which it referred to as the enforcement principle, borrowing the expression used by Lord Justice Beatson and then by Lord Clark in Appellant. So behind tab 36, if I could ask you, my lords, my lady, to go to page 797. In paragraphs 84 and 85, the court makes the point that's also made in Harrington and Charles and by my learned friends in their skeleton, that that a freezing injunction differs from an American sign of an injunction in this respect, that the court isn't seeking to vindicate in a temporary way the claimant's cause of action. But as I've already said, that shouldn't matter, because unless one's dealing with a post-judgment freezing injunction, the claimant is still seeking to vindicate in a temporary way a right that hasn't yet been established. If I could ask you please to go forward to paragraph 89 on page 799. One sees this just below B, in the passage where Lord Legate said, the interest protected by a freezing injunction is the usually prospective right to enforce through the court's process a judgment or order for the payment of a sum of money. A freezing injunction protects this right to the extent that it's possible to do so without giving the claimant security for its claim or interfering with the respondent's right to use its assets for ordinary business purposes. The purpose of the injunction is to prevent the right of enforcement from being rendered ineffective by the dissipation of assets against which the judgment could otherwise be enforced. So we say, with respect to summarise, that there's absolutely no principled basis for adopting a different approach to costs in the case of freezing orders from the approach that's taken in ordinary American cyanamide injunctions. In both of those instances, the court is interfering with the defendant's freedom of action on the basis that the claim might, in due course, obtain judgment. And if that judgment is refused, then with hindsight one can say that the interference wasn't justified and the claimant shouldn't have to pay the costs.
How far does that logic go? Would that logic also apply to an application for disclosure against a defendant that a defendant sought to resist? I might think in that case, well, it's perfectly obvious who the successful party is, it's the claimant, to which the defendant would say, well, I wouldn't be having to do this if the claim is bad, and you won't know whether the claim is bad until trial. And in just the same sense as was thought to be the case in Duquesne and Picnic at Ascot and Melford, you couldn't see who the successful party was until you'd had the trial.
Well, my lord, one sees, not least from Melford Capital, the courts, including this court, taking the view that just because one knows what the outcome of an application is, one knows that an injunction application, for example, has been successful, an injunction has been granted, it doesn't follow that the applicant is a successful party for the purposes of CPR 44.2 because it's all provisional.
But my lord's point is I'm troubled by the same point with respect. I mean, you put this very elegantly, if you don't mind my saying so. I just wonder where it goes to, because logically, in the example of a disclosure application, the defendant would say, well, given that the whole proceedings were misconceived, I should never have been subject to a disclosure order at all. Therefore, I should when one's looking at prospectively at the interlocutory stage, the defendant says to the court, well, don't make an order for costs against me, even though I've wasted 3 days of court time dealing with a disclosure application which I've lost. Because at the end of the day, if I'm right that this claim is a hopeless claim, then I shouldn't have to pay any of these costs at all. And I mean, that's essentially the point that is made against you, I think. And that's really what drives those decisions which have, mainly in the context of freezing injunctions, I agree, decided that costs should be, there should be an order for costs, is in situations where a party has spent a considerable amount of time on particular interlocutory issues, but has lost. I mean, this case, if we're against you on good arguable case, it is conceivable, I suppose, that we would decide that the Niedersachsen test applies, which is a pretty low threshold in one sense. But at the end of the day, you might succeed at trial. But it wouldn't necessarily follow from that you should recover the costs of having fought for 2 days over what the test was for good arguable case.
No, I see the force of my Lord Justice Popplewell's point. But I just turn for a moment, because I think Mr. Olive Cooper is trying to attract my attention.
No.
think I've 2 points. The first is, as will be obvious by now, we've approached this in terms of scrutinising the perceived distinction between interim injunctions generally and freezing injunctions. So we've obviously approached it from a slightly different angle. It's firmly established what the usual order is in an American cyanamide injunction case, and we say that there are the supposed distinctions between that situation and freezing injunction situation don't stand up when properly scrutinised. The other point, and the distinction between, for example, the disclosure setting that my lord mentioned is, I mean, in relation to freezing injunctions and in relation to injunction applications, there is an element of, well, there's a merits test. There is an analysis of the merits to some degree. That's not something which happens if I apply for disclosure. It's not contingent on
That may
whether I
not be the battleground on a contested freezing order application. It may be that the battleground is, I quite accept whatever the merits test you get through it, but no risk of dissipation. And we have 4 days on that, and the defendant, let us say, loses on that.
My problem is,
And
sorry.
you would still say, well, you apply the logic, you can't say that the defendant is the unsuccessful party, because this is all dependent on whether the claim is made good at trial. Or do you confine it to cases in which the contested issue is on the merits?
Well, that was, I think, rather clumsily, that was the distinction I was trying to draw between injunction applications and freezing injunctions on the one hand, and on the other hand, disclosure applications, matter of fact.
No, sorry, I haven't made myself clear. It may be that a contested interim injunction or freezing order application isn't concerned with the merits at all, because there's no issue taken on that. And the dispute on which the costs that we're concerned with are spent is about some other aspect.
Dissipation.
Dissipation, let us say. As you say, that still falls within the general rule for interim injunctions and extended to freezing orders, because you still can't say who the successful party is. Or are you saying, well, at least where the dispute is about the merits, then that's the case where the cost should be reserved? Because that doesn't seem to be a distinction that was drawn from the outset in the Duquesne and Vinny-Kadaska cases.
I mean, there is a well-established principle in relation to injunctions generally, and we say that should apply equally in relation to freezing injunctions, even if at a particular hearing the battleground is in relation to risk of dissipation.
Yes.
The reality is, even if it's assumed or conceded for the purposes of the application, there's a good arguable case. The reality is that there wasn't actually a good claim if it transpires at trial, that the claim is a bad one.
Yeah, I follow that.
So it's the contingency on that which applies in those cases, which doesn't, in my submission, apply with the same force or any force in relation to an application of disclosure, even if that is for the purposes of...
Just because for the disclosure application you're not examining the merits doesn't mean that they're not challenged in the wider sense that they're challenged on a freezing order application in which the defendant doesn't choose to say you can't get over the good arguable case threshold.
I do see that, my lord.
I entirely understand the way you put the argument. I'm just a little bit troubled with where it ends.
Where it ends.
I mean, that's clearly what drove the judges. I mean, you know, we've got a very detailed appeal from what was an incredibly short judgment after some argument I think when he handed down his judgment, and it's dealt with in about 5 paragraphs. But the judge was clearly driven by exactly this point, that time had been taken on the good arguable case argument in circumstances which went beyond what would normally happen on an ordinary return date, and therefore he took the view that that was a situation in which he was justified in concluding that your client should pay the costs.
Well, I'll come back.
And he makes it absolutely clear that was not intended to be an indication that that was appropriate in every case, just in this case.
Well, I'll come on to the judgment if I may.
Yeah, sure.
In just a moment. Can I just have a moment? I'm grateful. Conscious of the time, there are some Australian authorities in the authorities bundle, not by invitation this time, as the Commonwealth authorities on the main issue are.
Yeah.
Can I just flag them rather than asking my lord, my lady, asking you to go to them? The first is in volume 4 behind tab 56. A case called Southern Equities and Bond. I just flagged paragraphs 4 and 5. Paragraph 4, the plaintiffs seek an order that they recover the costs of the application. The defendants and other respondents to the application submit the cost should be in the case, contending that as the application is in aid of the execution of a judgment the plaintiffs might obtain, the plaintiffs shouldn't be entitled to their costs if they ultimately fail to establish any liability in the defendants. And then paragraph 5, a moravian order is interlocutory in nature in that it regulates dealings in assets pending the hearing and determination of action. Generally speaking, when a plaintiff obtains an order for an interlocutory injunction, the order reserves the question of costs for the trial judge, or the order is that costs should be in the cause. The reason for an order that costs be in the cause is that the successful plaintiff should have his costs if he succeeds in the action, but if the defendant succeeds, he shouldn't be ordered to pay costs incurred in opposing an order which is proved to be unnecessary. The principle applies with equal force to moravian orders. The court may, of course, depart from that general principle when the circumstances of the application and the conduct of the parties require it to do so. So I mentioned it saying that in Australia, there's no, well, as appears from that case, South Australia, there's no distinction drawn in this context between interlocutory injunctions, generally speaking, and moravian orders. And then there are, as I say, a couple of other cases which I'll just mention. One is Rima Tip Top Asia behind tab 57. There was a freezing injunction continued following a contested hearing. One sees paragraph 8, the judge saying the laws summarised in another case, rather splendid name, the claimant being His Eminence Metropolitan Peter. There's paragraphs 23, 24, 26 and 27, talking about what the usual order is, and we say that one gathers from that that in Australia it seems that the same principles are applied to the cost of freezing order applications as to other interim injunction applications. And the final Australian authority, volume 4, behind tab 58, YAJ1 and Opera Australia, at paragraph 15 on page 1225, the notion of an application being retrospectively justified because it turns out at trial that the claimant wins the case, which chimes with the issue that we've been discussing. So dealing very briefly with the judgment, and my lord, I accept the point which my lord Chancellor has already made in relation to paragraph 8 of the judgment in particular, where the judge says that he's making his order because of the circumstances in which this application has come about, rather than because of general views about what's appropriate in the general category of freezing orders. But we say with respect that the context in which he embarked on that exercise was itself flawed, because he was in error, we respectfully submit, in relation to what the usual order in relation to freezing injunctions ought to be. So it's behind tab 9 in the core bundle, my lords, my lady, page 117 and following, the actual.
Sorry, where do you say that he was wrong as to the usual order as to freezing injunctions?
Sorry, what I was saying is in paragraph 8, I think it's the point, my lord, that you made a moment ago, that he says that he's making an order for costs because of the circumstances in which this application has come about, rather than because of general views about what's appropriate in the general category of freezing orders. But we say that, and I'll come back to the special features, so to speak, in a moment, but if one looks at paragraph 2, paragraphs 1 and 2, he starts off by saying, in relation to interim injunctions generally, costs are reserved. That's summarising the law unfairly broadly for 2 reasons. One is that in that context it may be difficult to say who the winner and the loser is because the merits aren't considered in any detail but on the basis of the balance of convenience. And the second is because winning is in any event provisional, because what happens at the interlocutory stage may be undone at trial. He says in 2, in the context of freezing injunctions, the position is not quite the same. The merits are looked at in a different way, not on the basis of a serious case to be tried, but on the basis of good arguable case, whatever that means, but also because the provisional nature of the relief that's granted is also different. The freezing injunction, even if the claimant wins, will often not be turned into a final injunction. The basis on which ordinary interim injunctions are either made into permanent injunctions or not is more directly related to the merits when decided at trial. So it's both easier to say, even at the interim stage, who the winner is and who the loser is in the context of a freezing injunction, and also not quite right to say that success is only provisional, and then says there's no strict or general rule that costs will follow the event in freezing injunction cases, and goes on to look at what factors might be involved. But my lord, and you've heard my lords, my lady, you've heard my submission on this. Whilst there are distinctions that can be drawn between cyanamide injunctions and freezing orders, the reality is that in each case, the relief granted is provisional because the assessment of merits is necessarily subject to what is ultimately decided at trial. And the fact that there is no such thing as a final freezing order, subject of course to freezing orders being granted post-judgment, isn't a sufficient or indeed logical point of distinction between freezing order cases and interim injunctions generally. But it is clear in my submission that the learned judge rejected the notion that the court's starting point should be costs reserved, basically for the reasons given in Harrington and Charles, and we say that with respect he was wrong to do so for the reasons that I've given. So the starting point, the correct starting point, we respectfully submit, should be costs reserved. And then one asks whether there are any special factors that should lead to a different result. Now the judge wasn't asking himself quite that question, but he identifies 2 features of the case which he says were effectively salient in the exercise of his discretion. The first is in paragraph 5. The application was made on notice, and so my client had a long time to consider her position. But the mere fact that a party has contested an application on notice isn't enough to displace the usual order. Otherwise, it would have had that effect in Melford Capital and Alassane. So this isn't one of those cases we say where the merits were so clear that we ought to have just rolled over. And indeed, one might say that that's reinforced by the fact that we're here today, this court, having come to the view that there was a real chance of overturning the judge's decision. The second point that he makes is in paragraph 6 and 7, where he says that he's had to engage with the merits in more detail because of the argument over the meaning of good arguable case. But again, we say with respect, that's not relevant because the judge didn't decide the merits. He merely found that Unitel had the better of the argument on the material available. Whatever the differences may be between finding that there's a good arguable case and finding in the American cyanamide context that there's a serious issue to be tried, and as we've already touched on, there may well be issues as to how far apart those tests are. those two exercises are analogous, and neither involves the court deciding upon the merits of the case. So we say that neither of the factors that seem to have played a part in the judge's thinking provides a reason in this case to depart from what we respectfully maintain is or should be the usual order, which is costs reserved. Our fallback position, I suppose, one could make an order for costs in the case or claimant's costs in the case, as the Australian courts do, which would mean that we wouldn't have to pay the cost of the injunction if we're successful at trial. But we say that there's a very close analogy between the freezing order context and the cyanamide context, and no proper distinction between those two situations so as to justify a different approach in the context of freezing orders. And as my lady, those are my submissions.
Thank you very much. Mr. Sinclair.
Thank you. I'm going to try and get this done before lunch because my learned friend has taken the court to all of the authorities that are in this area and have done so in a fair way, so I don't think I need to repeat that exercise. That we have 3 points to make on this. The first one is that the court should rarely interfere with a first instance judge's decision on costs. Secondly, the question of principle, and thirdly, how that principle should be applied in this case. So the first of those is, I can deal with very quickly, that it's trite that decisions as to costs lie in the discretion of the judge, and the Court of Appeal will only interfere with an exercise of that discretion if, for example, the judge has made an error of principle or has made an order that no judge could reasonably have made. Here we say the judge made no error of principle and he exercised his discretion appropriately. Indeed, prima facie, it's unsurprising that a defendant who fights tooth and nail an inter partes application for a freezing injunction taking every point available should have to pay costs when she loses on every point. So that's the first point. Secondly, is the principle. We say there is no rule or starting point that the usual order is that costs should be reserved for a freezing order and there's absent special factors. The true starting point, if any, is CPR 44.2, which provides that firstly that the court has the discretion as to which party should pay costs, and secondly that the general rule is the unsuccessful party is ordered to pay the cost of the successful party. We accept that in the case of an interim injunction, an American cyanamide injunction, there is some suggestions in the case law that the starting point is different because interim injunctions are designed to hold the ring until trial. But that is not the case in our submission in relation to freezing injunctions because, and there is an important distinction between interim injunctions and freezing injunctions, because in the case of an interim injunction, the court is allowing, or in normal case, is allowing one party to enforce or rely on a right or an obligation, the existence of which is yet to be established. And whether or not that right or obligation exists is the question, or is a question, which will be established at the trial. So the court is coming down on the side of one party on the question that will be decided at the eventual trial and allowing one party to exercise a claimed right in the meantime. Whereas in the case of a freezing injunction, the court is granting an ancillary order in aid of the relief which is sought in the case. They're not granting the claimant early access to the relief that they're seeking in the underlying action. They're simply granting an ancillary order in aid of the relief that they are duly seeking. And so when a freezing order is granted, the claimant has established there and then the existence of a right or interest in not having his potential future enforcement undermined by the unjustified disposition of assets, and that's the convoy case. that my learned friend took you to. In the passages he took you to are 84 to 5 and 89. And what is protected, the potential future enforcement.
Sorry, could you just give me that again?
I'm sorry, it's
Right, the proposition.
Yes.
You put forward that in a freezing order case.
Yeah.
The right which is established finally at the grant stage, because he's established a right to have, what's the next bit I didn't get?
Oh, sorry, right. He's established there and then
Yeah.
the existence of a right or interest in not having the potential future enforcement undermined by the
Sorry,
unjust
just take it easy. The potential future enforcement
undermined
and
by
the
the
potential future enforcement of what?
of his substantive interest.
Which he may or may not have.
Indeed. But he does have.
So if he doesn't, in fact, as is ultimately determined, have a claim and therefore have a right a right to enforcement, he still does. He has an independent and freestanding right established at the freezing order stage for the potential future enforcement.
Yes,
I find that difficult.
he has the right immediately to protect his future enforcement. I think that is.
Can you show us where that?
Yes, let me pick it up. It's in.
It's not a passage in convoy collateral that I've looked at, I think.
Well, it flows from 84 to. So it's in convoy. Well, it flows from, let's say, convoy, which is tab 36,
Yeah.
paragraphs 84 and 85.
Yeah.
And 89. So it's really, and so in 89, about 5 lines down in that passage, the interest protected by a freezing injunction is the usually prospective right to enforce through the court's process a judgment order for the payment of a sum of money.
Right. So if it subsequently turns out that he's not entitled to a judgment order for the payment of a sum of money, how can he then have an interest in protecting that right by a freezing injunction?
Because that's one of the protections this court offers, is that it offers you by way of the freezing injunction jurisdiction, a right to, or a mechanism to protect your prospective right.
Right, as does an interim injunction, but both of them are dependent on you having the prospective substantive.
Yes,
right.
but in the context of an interim injunction, what you're being given is the substantive right at an interlocutory stage. The right to some employee can't work for someone else, for example. And so the employee is banned from working for someone else. So you've enforced your right to prevent that employee working for someone else immediately, even though you haven't established that right until the trial. Whereas in a freezing injunction, we our right here that we're claiming in this action is a debt. And the court is not enforcing that debt. It's saying you have a right, Unitel, to the protection of your prospective right to a debt that we're going to evaluate. And you have a right now to be protected now, so that if that is vindicated at the trial, you're protected.
So how does that distinction work in the kind of case one actually quite often gets, where you have a cause of action which is proprietary in nature, it's a constructive trust claim, and the claimant says the defendant's been a dishonest assister and I want a freezing order over their assets in support of my cause of action. I also say I've got a sufficiently arguable case, but I've got a proprietary claim because until we get some disclosure, you could reasonably assume that some or most or all of his assets are derived from the breach of duty. In one case, it's an interim injunction. In the other case, it's a freezing order. But in practice, it's both. So are the costs to be dealt differently?
But where you have a proprietary injunction, well, I don't know, it will depend on the situation, but
In the situation I've given you,
Yes,
would the
but
costs fall to be dealt with differently?
But in the situation where you've been granted a proprietary injunction, you won't have all the rights of an owner of the asset, will you, in the meantime? Well, it may depend, but you won't be allowed to use the asset
No,
as if it were yours.
That's my point. A proprietary freezing order, we've been using freezing order
Yes.
in the old sense of a Moreva,
Yes.
but a proprietary freezing order
Yes.
is a form of interim injunction.
Yes, exactly. But it holds the ring, and so as in the same way as so that is more analogous to a freezing injunction. I would agree, because it's saying, let's just protect this asset pending the trial. But it's not giving you, the person who claims the proprietary interest, all the rights to the asset that you will have if you win at trial.
No, but is it not an interim injunction in terms of categorisation? It's not protecting you by reference to a right to enforce against the defendant's assets if and when you get a judgment against the defendant. It's saying these are my assets,
Yes.
and they must be protected in the meantime, in just the same way as if you had a claim to a car.
Yes, well, I can certainly see that the argument in a proprietary injunction situation that the picnic at Ascot jurisdiction shouldn't apply. I can see that argument.
So in the example I gave you, where actually the application is put forward on the same basis,
Yeah.
in two different ways.
Yes, it's the same. It would be the same.
It would be the picnic at Ascot test.
No.
You would then in that case. Well, why not?
No, because that's what I'm suggesting is that in a situation where you're just seeking a proprietary injunction on an interlocutory basis, the winner of that application would make the same sort of argument I'm making, that it's not a picnic at Ascot scenario, that one, and that is where there's a clear winner of the who's been granted the proprietary injunction, just as a clear winner where someone's got a freezing injunction.
Sorry, it's my fault.
It's
I'm
much-
afraid. So in the example I gave you of a proprietary freezing order,
Yeah.
do you say picnic at Ascot applies to that or not?
No,
Because
it should be treated analogously to a freezing injunction, as your lordship says. So it's effectively the
Why?
same.
Why is that to be distinguished from an American sign?
Because in an American cyanamide situation, that you are being granted the very thing that you are claiming in the action, pending, even though you haven't got to the trial yet.
that's the case for a proprietary freezing order.
Well,
You're saying this is my money. At trial, I'll be able to trace into it.
Yes,
I'll
but
be able to get an order at trial. And this
Yes.
is part of my pleaded claim that these assets belong to me. That's
You're
part
not
of the
allowed to
substantive relief.
sorry,
Sorry.
but you're not allowed to spend that money spending the trial. It's just frozen there for no one. Whereas at the trial, if you win, it's now your money, you can spend it. Whereas for an employee, where you say that employee can't work for my competitor now, and the judge says, yes, all right, he can't work for the competitor now.
I understand if you take an employee as a paradigm,
Well,
they're different. But take for a moment,
Yeah.
not a proprietary freezing order over assets,
yes.
but a proprietary interlocutory injunction in a dispute about who owns a car.
Yes.
Does picnic at Ascot apply to that or not?
Well, again, it may do, yes. So exactly. So that if the judge says, well, pending the trial,
In the trial, the
The
car's
claimant
going to
can
stay in
use
the
the-
garage.
or the claimant can use the car and drive around,
No, the car's going to stay in the garage.
well, then that's
the example.
that's equivalent to a freezing injunction, I would say, and the same rules should be taken on costs.
So any interim injunction, is this your case, in which the balance of convenience favours something which holds the ring rather than gives
Yes.
the claimant what they're asking for,
Yes.
comes outside picnic at Ascot?
I would say so. That's the logic of
It's the
that's
logic of your
logical.
argument, but it's quite surprising, is
Well,
it?
I don't know this is because that is one of the main reasons behind picnic at Ascot is you're just holding the ring.
Yes.
And if you're not just holding the ring, but something else is happening, then picnic at Ascot shouldn't apply. And we say that's one of the reasons
No,
why.
sorry, I think you may be misunderstanding my example. Because I think the example I gave to you was dispute over a car.
Yes.
The order is the car's going to stay in the garage, neither of you can use it.
Yes.
Does picnic at Ascot apply? And I think your answer was no, because in that situation,
Yes.
you're not giving the claimant what the claimant is asking for.
Yes.
But that is a classic example of holding the ring,
Yes. Yes.
which is what picnic at Ascot is all about, isn't it?
No, but as some of the cases that my friend took you to, is that the courts consider that the type of injunction that just freezes something, a car, whether it's a car or money, is holding the ring in a different way to the situation where you're just maintaining holding the ring in the sense of deciding what the status quo should be. You're not freezing. I keep coming back to the employee one because it's a useful counter analysis. That in that situation, you're not holding the ring in the same way because you're giving, the judge is deciding that one person should have the right that's in issue at trial now or should not have it, depending how it goes. Whereas in the car situation, the judge is saying, no, let's just wait and see.
Well, circumstances alter cases, but I can envisage, even in an employment dispute, that the balance of convenience may involve allowing the employee who it said is in breach of a restrictive covenant to work to some extent for the competitor, but with safeguards in relation to what he or she can or can't do. It's not a question of giving either side what they say is the vindication of their rights.
I see that, but all we're talking about here is the starting point, aren't we? So, ultimately, the question of course comes down to the judge as a matter of discretion based on the facts of the particular case. And so, and even in an American cyanamide situation, I think everyone recognises that the circumstances may be that a cost order should be made immediately. It's just that the starting point is that one doesn't. And likewise, I would submit that there's just no starting point here. It may be in a freezing injunction case, the court says, yes, let's reserve the trial. Obviously, it's up to the judge. So it is a fact.
Your point really comes to this, doesn't it? That whether the starting point is cost reserved or not in a freezing injunction case, which is what Mr. Margolin asked. In a case in which the defendant fights, as you put it, tooth and nail, the good argument, what the test is, and whether or not it's satisfied, whatever the test is, assuming that the claimant loses on that, the defendant loses on that, they should have to pay the costs straight away.
Yes, I'd say
It's
that.
at least within the discretion of the court to order them to pay the cost straight away.
Yes, well, I do say that, but that's the third limb of my argument.
No, I understand. I'm trying to see where we're getting to.
Yes.
I think it might be sensible if we actually had a break, so you can
Yes,
just have to
okay.
think about.
Yes,
Rather than trying to sort of rush it through.
I'm not going to finish in 4 minutes.
I don't think you're going to finish in 4 minutes.
But should I keep going to 1 o'clock?
Well, let's just break, shall we? We'll
Okay.
break now and come back at 2 o'clock.
All rise if able.